In today's lecture, we're going to talk about the agency relationship. As we'll see, there are two different types of agents. There can be employees who are the agents of the employer, and there can also be agents who are not employees, but who are commonly called independent contractors. The law of agency developed as a way to increase the growth of the economy. Because if an owner of a business is the only person who can enter into contracts on behalf of the business and take other action on behalf of that business, there's only so much that one person can do. When agency law was created, it was so that the owner of a business could appoint others to also act on behalf of the business, even though they weren't owners. So for example, assume that you are the owner of a used car lot, and it's a huge lot. It goes on for blocks, and you're the sole owner. If every single person who comes to that lot to buy a car has to deal only with you, how many cars do you think that you can sell in a given day? Maybe 7, 8. But if you have 30 sales agents working for your business, you can multiply the number of cars that you can sell on a daily basis by 30. So the existence of an agency relationship is a very important aspect of our business world. So let's break it down to some basics. First of all, what is the definition of an agency? An agency is a two-party relationship in which one party, who is the agent, has the power to act on behalf of, but subject to the control of the other party. And the other party who engages the agent is called the principal. Now, one thing I want you to note here, when we use principal, the word principal in the sense of an agent and a principal, principal is spelled P-R-I-N-C-I-P-A-L. It is not principle, P-R-I-N-C-I-P-L-E, which is a belief or a value. The way we learned to tell the difference when we were in elementary school was that we would have this saying of, the principal is my pal. If we're talking about a person, it is, the word ends in P-A-L. An agency relationship is created very easily. An agency is created when the principal manifests assent, which is basically saying, I agree to this, to the agent, that the agent will act on the principal's behalf and subject to the principal's control. It doesn't need to be in writing, it can be oral, and it can be very short. I'd like you to go out and sell my car for me. Make sure you get at least $3,000 for it. That's something that could create an agency relationship. Whether or not an agency relationship has been created is judged by an objective standard. And we're going to see objective standards and subjective standards being referred to throughout the semester. When an objective standard is used, it doesn't matter if the principal and agent themselves intended to create an agency. It is whether a separate party, a third party, hearing the words spoken by the principal to the agent would conclude that the principal was engaging the agent to act on the principal's behalf and subject to the principal's control. This is important because a lot of times people in their contracts, particularly when they're their written contracts, will try to contract and say, we aren't creating an agency relationship. Because as we'll see in a little bit, there are a lot of responsibilities that come along once there's an agency. So the parties to a contract will say, nothing herein is intended to create an agency between us. When absolutely, they're creating an agency. I used to see those kinds of clauses all the time in motion picture contracts. A motion picture studio would hire someone to produce a motion picture for the studio or to direct that motion picture. And they would put in their contracts, you're not our agent. We're hiring you to act on our behalf in producing this motion picture. And of course, you have to be under our control and follow our instructions. But we're not creating an agency here. The courts will disregard that language because of the use of the objective standard. It doesn't matter what the parties think or what they intend. It's what an objective third party would think under the circumstances. Who has the capacity to be an agent? Who has the capacity to be a principal? Now, this is rather interesting. A person has the capacity to be a principal only if that person has the capacity to do the acts for which the agent is being retained. If a principal engages an agent to negotiate a contract on the principal's behalf, the principal must have the capacity to enter into that contract directly if the principal were negotiating the contract him or herself. Now, if you think back to your Business Law 1 class, where we talked about whether parties had capacity to contract, we learned that there were 3 categories of people who lacked capacity to contract. And those were minors, those were people with mental incapacity, and they were intoxicated people. So if you fall into one of those 3 categories, you cannot be a principal. You cannot engage an agent to do something that you couldn't do yourself. The interesting thing is that the agent you engage doesn't have to have capacity. It only matters if the principal has the capacity. So a principal who has capacity could engage a drunken, stoned teenager to negotiate a contract on the principal's behalf, and that would be a legitimate agency. Probably not a wise decision, but under the law, a legitimate agency. Now, as I started out saying, there are 2 different types of agents. There are agents who fall within the category of an employee, and there are agents who are not employees, but are still engaged to act on behalf of and under the control of the principal. There is an important distinction as to whether or not someone is an employee or an independent contractor. A lot of legal liability depends on whether or not the agent is classified as an employee or an independent contractor. We've already seen this in the case of CBS Corp versus FCC that we used for our briefing example. All right, in that case, there was a huge fine, $550,000. And the validity of that fine turned on whether or not Justin Timberlake and Janet Jackson were employees of CBS or independent contractors. Now, because of this, because there's a lot more liability that comes to the principal if an agent is an employee, many principals try to say that someone who is really an employee is only an independent contractor because they want to escape the additional liability that comes with having an employee. It's not just legal liability. It's things like having to withhold payroll tax for that employee. It's having to supply certain benefits under the law if they're an employee. So many employers try to avoid this by characterizing who should be employees as independent contractors. Oftentimes then, the courts are called upon to have to decide whether an agent is an employee or an independent contractor. Right? Usually the employer characterizes them as an independent contractor. Someone comes in and tries to challenge that to say they're really employees, And then the courts are called upon to decide employee or independent contractor. The legal test that is used to determine whether an agent is an employee or an independent contractor used to be uniform among all of the states and also under federal law. California has now removed itself from this test, and we're going to talk about that in the next slide. But with respect to every other state and under federal law, the courts use a balancing test. And they weigh a number of factors, just like we saw in the CBS Corp versus FCC case. They weigh a number of factors, about between 10 and 12 factors. And they weigh those factors differently depending on the circumstances of the case. Generally speaking, although we saw that was not true in the CBS Corp versus FCC case, the most important factor is the principal's right to control the manner and means of the agent's performance or work. But as we saw in CBS versus FCC, the court in that case found that the right to control wasn't as important as some of the other factors. So it's a balancing test where all of these different factors are given different weight depending on the circumstances, depending on what court might be hearing the matter. That means that two courts hearing the exact same case could come out with two different results because the judges weigh the factors differently and give some of them more weight than the other. And both of them would be acting correctly under the law. This is one of the many areas where we'll see the law is a little bit frustrating because, I'll keep saying in this class, we always strive for certainty in the law. We want to know how to conduct ourselves because we have bright lines about what falls within the law and what doesn't. And this is just one of the many areas where there's no real certainty because courts applying this balancing test can come up with two completely different answers under the exact same facts, and both of them will be acting within the law. Our state of California finally got fed up with the number of principals who really should be treating their agents as employees, not treating them that way, and as a way trying to avoid their legal liability and responsibilities to their employees. And California was frustrated with this balancing test because of what I just said. There was no clear rule. There was no certainty as to how these cases would come out. So, in a recent California Supreme Court case, and it's so recent it's not even in your textbook, even though your textbook is relatively new. In the spring of 2018, the California Supreme Court issued an opinion in the case called Dynamex Operations West versus Superior Court. And in that case, the California Supreme Court rejected the balancing test. They said it's a test that doesn't work. We are going to throw it out. And the new law in California is that we are going to presume that every worker is an employee. Everyone who works for anyone else, we're presuming that person is an employee. And if somebody wants to challenge that classification, to try to show, no, this person really is an independent contractor, the person challenging the employee classification has to prove each of three things. Right? If they only prove two, that worker is an employee. They have to prove all three in order to succeed with an independent contractor classification. And the three elements that person must prove is: number one, the worker is free from control and direction of the principal. Number two, the worker performs work outside of the usual course of business of the principal. Right? So that means if the principal sells jewelry and you're engaged to sell jewelry, you're not performing work outside of the usual course of business. You're in the course of business of the principal. Now, if that same seller of jewelry hires me to be the owner's lawyer, I'm performing legal work. And that is outside the usual course of business of the principal. And the third element that must be proven is that the worker is customarily engaged in an independently established trade or business. I have to have my own business that I regularly engage in outside of what I'm doing for the principal. And unless each of these three things is proven, you in California are an employee. Now, when this decision came down, it created panic for a lot of employers in California who had for the longest time been treating their workers as independent contractors. Probably no one was more panicked than Uber, Lyft, Postmates, those types of gig employers. Their entire business model is based on the fact that their workers are independent contractors. But look at the three tests. Look at the three tests. Is an Uber driver in California an employee or an independent contractor? Well, Uber did not like the Dynamex decision, and it immediately went to work in California to try to get out of it. So, what did Uber do? The first thing that Uber did is it lobbied the California legislature to pass a law excluding Uber from the Dynamex rule. So this was a bad law, it was too broad. And remember, who was supposed to be making law? Judges are supposed to be interpreting the law. They're not supposed to be making the law. So Uber went to the California legislature and said, you're the ones who are supposed to be making law. So pass legislation that exempts gig principals like us from having our workers classified as employees. And the California legislature took Uber up on that. And it, in fact, passed a statute on this very issue of when is a worker deemed to be an employee in California. But much to Uber's chagrin, the law that the California legislature passed, which is called Assembly Bill 5, adopted the Dynamex rule. They said, we think that's a great law. Thank you, California Supreme Court. And we are going to make our statute so it's really clear that that is, in fact, now the law in California. So to embrace the Dynamex three-step test. The California legislature did exempt certain principles from the Dynamex opinion and say that they are still, those types of principles are still subject to the balancing test to determine whether someone was an employee or an independent contractor. There's some odd groups like barbers and cosmetologists, you know, the owners of a haircutting salon. They are exempt from the Dynamex rule. But much to Uber's chagrin, Uber, Lyft, Postmates were not one of the exempted categories. What does Uber do next? Uber took the position that it met all three elements set out by Dynamex. So its workers were independent contractors even after the Dynamex test. How did they do that? Well, number one, they said, hey, look, our drivers aren't under our direction and control. They set their own hours. They decide who they want to pick up, when they want to pick up. We don't tell them. We just make the opportunity available to them. But we don't control the way they drive. We don't control when they have to work. So they're not subject to our control and direction. And with respect to the third element, that the worker has to be engaged in an independently established trade or business, Uber said they do have their own business. They're drivers. They don't necessarily just drive for us. In fact, a lot of these workers, they drive for Uber, they drive for Lyft, they drive for Postmates, they drive for all, that's their business. That's their independently established trade or business. Right? Now, I would say, as to those two arguments, Uber probably could make that case to say, you know, it could go either way, but I could see where Uber might be able to make that case. With respect to the second element, where the second element requires that the worker has to be engaged in some business outside of the normal course of business of the principal. Right? Now, at first blush, Uber's in the driving business, and the drivers are in the driving business. So they are working within the scope of Uber's business. It seems to me, on first blush, slam dunk. Well, Uber came up with a really interesting argument. Uber said, we are not in the driving business. We are a technology platform. We don't drive at all. We just came up with this app where we match up someone who wants a ride with someone who wants to drive. We're the Match.com of the driving world. So we're not engaged in the same business. So Uber said they weren't going to comply. They weren't going to classify their drivers as employees. But even though they took this position, and that's the position they announced, I don't think they were 100% sure it was going to fly. Because the next thing that Uber did is they circulated a petition to place an initiative on the ballot to have the voters pass a law that said that Uber and Lyft and those other type of gig principles were exempt from Assembly Bill 5. And I don't know if you encountered any of these petition gatherers, signature gatherers. I did. You'd walk outside the grocery store and they would say, hey, would you like to help protect Uber drivers? And what is put in the initiative is not only the fact that workers are independent contractors, but they promised to provide them certain minimal benefits. So they focused on that to secure their petition, right? You get health insurance for your Uber driver. Would you like to help them? Sign here. And Uber succeeded in getting enough signatures to place the initiative on the ballot. And it is on this ballot that you will be voting on in November. It's Proposition 22. So keep an eye out for that. We'll see what happens with it. In the meantime, however, and I am dictating this lecture on Tuesday, August 11th, yesterday, Monday, August 10th, a federal judge issued a preliminary injunction requiring Uber to immediately start treating its drivers as employees. Right? Enough of these delays, and you're trying to change the law, and you dragged it out, and you dragged it out, and you dragged it out. Enough is enough. This is in response to a lawsuit brought by the state of California against Uber. And the preliminary injunction is scheduled to go in effect in 10 days, so on August 20th. And Uber has, as of today, announced that it intends to seek an immediate emergency appeal. So it'll be interesting to continue to watch this and see where it ends up. But in any event, California now has a dramatically different test for whether a worker is an employee or an independent contractor, and many, 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 many more workers in California will now properly be classified as employees with the resultant responsibility on their employers to do the things that employers are supposed to do.